Chair now recognizes Mr. Roy for 5 minutes, and you can feel free to use your time.
Mr. Homan, I'll give you some time here in just a second on that. A couple things and observations. First, to Ms. Boyso, Mr. Sanchez in particular, thank you for being here. Wish you both well and long lives, and glad that you're able to get the care here. Ms. Boyso, I'm glad you're getting the kind of treatment you're getting. I, too, was in a program similar for a different illness, and I'm glad to be able to get kind of trial-type treatments, and glad that you're able to do that. A quick question that I want to try to, or statement, and then some clarification. It is my observation that when DHS rolled this policy change, for lack of a better term, until I get to the second panel to ask USCIS, when they rolled it out, it is my view that it was not rolled out the way it should be rolled out, right? It should have been rolled out a different way, and we'll see what that looks like in the next panel. If one thought that ICE was the best place to deal with deferred action, it would seem to me that the debate then is whether, the question here is where it should be. Should it be USCIS or should it be at ICE? And that if you were going to accept that premise, then what should have been done was much clearer notice given and a different kind of transition. Like, let's just assume for a minute ICE is the best place for it. Then a letter should have gone out, or a phone call, or reach out and say, hey, no issue, you're going to keep getting health treatment, we're changing processes, this is the way ICE is now going to handle it, and so forth and so forth. So I think I'd like to just stipulate that that's my view, that if you're transitioning the way you previously handled something, then you need to have something like that. We'll ask the second panel about that. Having said that, I am interested in continuing to learn where it should exist. We'll hear from USCIS in a minute. But I want to understand, Mr. Homan, on that question, we'll come to this other stuff in a minute, with respect to ICE and why you think it's the best place. Can you speak to the question at hand here about, I think, the fear of somebody's here, they're in a tough situation, and you're saying, okay, we're getting shoved into a pipeline for expedited removal, and then hoping there might be a question of discretion. Well, and can you kind of walk through how that might work in ICE?
Let's be clear in my testimony. What I've said is, as a law enforcement officer, prosecutorial discretion needs to be in the hands of those who have statutory authority over those laws. It is a case-by-case determination. Right. Once you carve out a whole class of people you want prosecutor discretion, there's no longer prosecutor discretion based on case-by-case. Now, we have talked about states. That's what ICE currently do. They give states removal. Mr. Marino, what he says, I'm not disagreeing with him. Is ICE prepared to make other decisions that CIS is making? That's a question for ICE in the next panel. Right. What I've talked about is ICE needs to have the authority of prosecutorial discretion, and that's a legal issue. And I think those decisions, no other agencies to say, well, ICE can't remove that person. That needs to be ICE prosecutor discretion, or you shouldn't put him in proceedings. That needs to be ICE's decision. Now, are they prepared to do that? Because they normally don't. You have to ask the next panel that. So I'm not lying under my testimony. I'm speaking to my 30 years of doing this and what I think prosecutorial discretion means.
So and the reason I think this matters, right, is the purpose of I hope there's general agreement about the process and the communication and what should have occurred there, that we can have a debate, as I think we had a good conversation, Ms. Ocasio-Cortez and Mr. Meadows, about, okay, where do we go forward on this, on that question? We'll ask the next panel some of these, but it is important for us not to send some signal of, panic, to use Mr. Meadows' term, that anything is going to be problematic going forward, that we'll address the issue and try to reconcile whatever gaps there are here. I do think it's also important to note on this question of deferred action, the questions of when it is a discretion for a prosecutor, right? This is at the court of DACA and DAPA, right? We had this litigation in DAPA. We went to the court, and the court agreed that that was something more than discretion. That was something beyond discretion. And I think what we see here in a sort of separation here is that what we're talking about here is discretion. I think Ms. Waddia, I was looking at your testimony, the data points there, you said, one data I was able to identify included 118 deferred actions, of which 107 were approved, pending or unknown, in a particular data set that you had, indicating that each one is case by case, and there were 8 that didn't qualify. I have no idea what those 8 were, but that's a decision by case decision. To that end, let me ask you one question, final in my last 5 minutes. Mr. Homan, would you like to address, and would you please address any of the
Yeah, I want to
statements made
address the
against
last comments made about me being appalling. And first of all, I served my country for 34 years. I saved many lives, and I ran an agency. Let's be frank in what ICE does. ICE last year took a season of opioids off the streets of this country that could have killed every man, woman, and child in the United States twice. They've arrested thousands of sexual predators that preyed on children. They rescued thousands of children who were victims of predators. They arrested hundreds of women who were victims of sex trafficking. I am proud of the agency and ICE. And what we don't want to talk about is nearly 90% of everybody ICE arrests for immigration violations either have a criminal history or are pending criminal charges when they were found. I mean, they were found in a county jail, which most likely means they weren't a choir boy. So to mismessage what the work the men and women of ICE do is, I find appalling that a member of Congress would throw that out there like that. In my 34 years, I've never seen such hate toward a law enforcement agency in my life that you want to abolish them rather than doing your job and legislate.
Mr. Homan, your
if
time
they don't
is
like
expired.
it, legislate. You can't.
Mr. Homan, according to the rules of this committee,
of enacting laws.
Mr. Homan, your time is expired.
For your service.
Representative Ocasio-Cortez for 5 minutes of questioning.
Thank you, Mr. Chair, and I would like to thank my colleague Ayanna Presley and Mr. DeSaulnier for your work also in organizing this hearing in a critically important issue at this time. Ms. Bueso and Mr. Sanchez, I want to thank you both for coming to testify. I would like to thank all of our witnesses for coming to testify before this committee. It is enormously taxing physically, emotionally, mentally, to come here and to testify before this committee and to prepare for your testimony, no less to testify for the length at which you all are doing. So I'd like to thank you. I'd like to recognize that you're doing it not just out of self-preservation, but to make sure that thousands of children and other people in the United States are protected. I'd also like to apologize to you both for the behavior of some of the members of this committee, where they are speaking in profoundly dehumanizing terms to you, and you don't deserve that. I'd like to apologize to you on behalf of the United States of America for the dehumanizing policies that they are pursuing that are frankly targeting you and targeting many people in the United States. And we're fighting for a better country that we can be proud of when it comes to how we treat all people and understanding the circumstances that they are coming from. And I'd also like to recognize the intrinsic value that you have and offer to everybody that you encounter in our country. Speaking of which, Ms. Bueso, do you remember long time ago, and you may not, but in 2003, participating in a clinical trial for MPS 6 in Oakland, California?
I was really young. I was 7, but I do remember coming here with my mom and participating in a clinical trial.
You said you were 7 years old?
Yeah, 7 or 8, yeah.
Do you remember,
in 2003.
Do you remember, and again, I know you were very young, but do you remember a girl named Mariel Abreu?
She's from New York.
She's from New York.
Yeah.
She's a constituent of mine. And she wants to write and submit to the congressional record a letter of support for you to stay in the United States. So, Mr. Chairman, I would like to seek unanimous consent to offer this letter to the congressional record.
Without objection, the letter will be entered.
And clearly you had a profound impact on her.
Yeah.
And I think it's a testimony to your character and just who you are as a person. That being said, Professor Wadia, direct and deferred action, rather, ensures that children can stay in the United States to receive treatment for life-threatening medical conditions without fear of being deported, correct? And the deferred action is subject to very strict internal controls. You have reviewed hundreds of these actions, of these cases, and the reasons for granting deferred action are generally limited to very serious life and death issues. Isn't that correct?
Correct.
So folks and people like Mr. Sanchez and Ms. Bueso are not collateral damage to this administration's policy. They are the target, correct?
Correct.
Is targeting and changing policy to specifically target people with life-threatening diseases for deportation, essentially killing them through deportation, would you characterize that as cruel?
I would.
This is a cruel policy change, and it fits a pattern that we have been seeing over and over again before this committee of a culture and policies specifically almost animated by cruelty. We hear over and over again, and we've heard it today from folks across this committee, that they're under-resourced, that we have to continue dumping billions of dollars into enforcement, into putting children in cages, into a system that is quite literally killing people. But meanwhile, we are adding to the resource strains by forcing people to go through the ordeal, forcing this country through the ordeal of needlessly deporting people like Ms. Bueso and Mr. Sanchez. Of course you're under-resourced for your goals, because your goals is to deport people that have no reason on humanitarian grounds or otherwise to be deported. Would you agree with that, Dr. Wadia? Is that an assessment? Is that how this strikes you?
The witness may answer the question.
It does, and it goes to my testimony about how we spend resources. This change in policy also throws a wrench into the rule of law because of the fact that discretion is such a necessary component and part of the rule of law. We have to make choices about who we're going to target for removal and who we're going to place in the back
And when we want to
burner.
talk about morale...
and the gentleman's time has expired now.
you.